Good morning, everyone. My name is Melissa Guller, and I am the Program Director of the National Council of Juvenile and Family Court Judges Child Welfare Program. And I have with me today Dr. Sophia Gutowski, who is a consultant with the National Council of Juvenile and Family Court Judges and the lead author of the Caseworkers Companion Guide to the Enhanced Resource Guidelines. This is the second part of the Caseworkers Companion Guide to the Enhanced Resource Guidelines, which is going to showcase the hearing checklist for caseworkers. We're really excited today to be able to unveil this new great resource, and we look forward to sharing with you the details. Before we get started, I'd like to pull up a poll. Stephanie, if you could pull that up. And we'd like to know who's here today. So if you could please select the option that best describes your current role, we'd really, really appreciate that, just so we know who's joining us today. Let's give it one more moment. Great, well, it looks like we have some folks from advocacy, court personnel, and TA providers. So thank you so much for joining me. At this time, I'm going to turn it over to Dr. Gutowski to talk about the goals and purpose of the companion guide.
Thanks, Melissa. So we developed a Caseworkers Companion Guide to be a partner in technical assistance to the Enhanced Resource Guidelines, which were developed to aid judges in improving hearing practice in abuse and neglect cases. So the Caseworkers Companion Guide includes checklists which mirror to some extent the judicial bench cards provided for judges in the Enhanced Resource Guidelines. They were developed out of a needs assessment process too. So we canvassed the field of child welfare professionals to determine what they felt they would need to help them better prepare for, participate in, and follow up after abuse and neglect hearings. We heard back that one of the most effective tools they believed for them would be a checklist much like the judicial bench card, where they could understand what the judge's expectations were for hearing practice and know how better to prepare to meet those expectations, ultimately to be more effective as a caseworker, a child welfare professional, in moving the case forward towards safe and timely permanency. So the companion document includes general practice strategies aligned with the Enhanced Resource Guidelines, but also has an overlay for considerations in cases involving domestic violence, so some additional practical tips and strategies when there's an intersection between child protection and domestic violence. The Enhanced Resource Guidelines and the Companion Guide are also developed on a number of key principles or ideologies that I'll turn it over to Melissa to give you some context about. But those kind of underlying philosophical tenets have implications for caseworker practice. We're going to give you a summary of what those philosophical guiding tenets are and pointing out how they affect caseworker hearing practice. We'll give you a tour of one of the checklists. We've selected the initial hearing, the preliminary protective hearing checklist for caseworkers, and then we're hoping to get your feedback, have a bit of a discussion at the end. So with that, I'll turn it over to Melissa.
Thank you, Sophie. As Sophie said, the key principles or philosophies that are really the underpinning of the Enhanced Resource Guidelines have implications for the caseworker's practice. And so each of the key principles really do sort of define the philosophy that we are trying to convey around using the Enhanced Resource Guidelines. But because the Enhanced Resource Guidelines were specifically designed originally to help with judicial practice, we certainly have seen how this is helpful to other players in the arena as well, in the court arena. So the first principle is around keeping families together, and that the foster care system is really a last resort, and the best place for a child is to remain in his or her home as long as they can be safe. And so the implications for caseworkers here is that workers can conduct a careful analysis about whether they are using foster care as an actual last resort. That making the case that reasonable efforts have been made to prevent a placement is one of the most important analyses a worker can do. It's critical that the worker provide the court with a fully thought out analysis as to why no in-home services or arrangements will keep the child safe, and that whenever possible, children affected by child maltreatment and domestic violence should remain in the care of the non-offending parent. Workers really need to properly identify domestic violence and assess its impact on the survivor and the child, and the safety and risk factors and needs, and build plans that allow children to remain with the non-offending parent. We truly view the survivor of domestic violence as a partner in protection. The other piece is to ensure access to justice, and that the juvenile court should be presumptively open to the public to allow for transparency and involvement of interested persons and family members. Both children and families should be able to attend hearings and speak to the court directly. And I know in some jurisdictions an open court seems like a crazy idea, but the National Council created a resolution several years ago looking at the importance of this transparency, and in many jurisdictions allowing a support person into the courtroom, and then that even included an advocate for the parents, was not something that was allowed. So ensuring that this key principle is adhered to really helps with that. And this also is an implication for the caseworker, because the caseworker's own beliefs about whether it's important for families to attend court may need to drive, in fact, whether they do attend, and caseworkers should collaborate with attorneys and advocates to explain to the court what they'll want to hear directly from the clients, and stress the importance of developing safety plans for domestic violence victims, and so that they can also participate in hearings safely. The next key principle is around cultivating cultural responsiveness. And this is really helping to remediate implicit bias, and is the job of everyone involved in the court system. And this includes judges, attorneys, caseworkers, foster parents, etc. And learning about one's own biases is an important step, and we encourage judges to ask family members about their cultural connections. And this is an implication for caseworkers, because as the first line of contact with families, a worker's interest in and respect for a family's culture and traditions is a foundational building block of developing a true partnership with a family. Caseworkers should participate in training to learn and identify their own bias. The next key principle is engaging families through alternative dispute resolution. Judges need to encourage the use of all alternative dispute resolution methods. And in cases involving domestic violence, judges really need to consider if the parties are able to effectively participate without compromising the safety of the survivor. This is an implication for caseworkers, because caseworkers should encourage and involve families in the processes in which the family is the key decision maker. And they should have a plan for how domestic violence survivor parents can safely participate in any alternative dispute resolution process. It's going to be important that the caseworker bring any of these concerns up to the court. Our next key principle is around ensuring child safety, permanency, and well-being. This principle really directs judges that they're responsible for ensuring the physical, mental, emotional well-being, and the reproductive health and educational success of children brought before the court. This emphasizes that the judge is also responsible for the safety of the survivor of DV safety both in the court and outside. And workers can ensure that judges have the necessary information that is thorough and up to date, and also make sure that informed decisions about the safety, permanency, and well-being of children, especially in cases involving domestic violence, workers should ensure that the survivor parent and the child can safely, oh, sorry, I just cut out. Let me repeat that. That cases involving domestic violence workers should ensure that survivor and child safety and offender accountability actually drive the case plan. I hope everyone was able to hear me. I apologize for that. The next key principle is about ensuring adequate and appropriate family time. And research has actually shown that family time, which is also known as visitation, is highly correlated with the return home of children. And we emphasize that judges should not only use form orders that cede all decision-making about family time to the agency, but they should not be used as a reward or punishment for parents and children. It should be as regular and often as long as the child can be safe and not tied to compliance of the case plan, for example. This has an implication for caseworkers because they should provide a thorough, individual, written explanation to the court for any plans regarding family time. And any safety threat should be clearly documented if a visit needs to be supervised. Another one of the key principles is around providing judicial oversight. And this is that all cases involving a family should be heard by a single judge, and if not possible, judges should ensure different courts and judges dealing with family are in close communication. This really facilitates the judge being able to see the big picture and pinpoint systemic issues that may be negatively impacting children and families. Caseworkers should understand the status and orders in any other cases in which the family is involved, which includes protective orders. The more information that you're able to provide to the judge, the better that this will ensure that the judge is making good decisions. The next key principle is around ensuring competent and adequately compensated representation. And this is really around all parties should have legal representation that's adequately compensated but also highly trained. And this implication for caseworkers is really around maintaining contact and involving attorneys and advocates for all family members and the child in the case in regards to decision making. The next key principle is around advancing the development of adequate resources. If families are not getting what they need, judges really should join the conversation to promote additional resources in the community. And it's important that caseworkers know, and it's emphasized, that caseworkers have firsthand knowledge of systemic barriers to doing their jobs and serving families well. They should document these barriers and forward to leaders in the agency who are working on collaborative system improvement. Another key principle that we certainly want to foster and emphasize to judges is the need to demonstrate judicial leadership and foster collaboration. Judges are uniquely positioned to lead both on the system level and on the case level. On the case level, judges should set clear expectations about how their courtroom will function. And this includes timely hearings with no unnecessary continuances. This should be among their expectations. And judges really have a strong say in the way families are treated in the court by not only themselves, but by other stakeholders. the implication here for caseworkers is who have the most contact with families, that they should work with the court to develop mechanisms to provide direct feedback to the court about how they and the families are experiencing the court process. This is really a vital piece of feedback to any effort. And now that we have a good understanding of the key principles and the implications, I am going to turn it over to Sophie so that she can actually unveil and provide information around the hearing checklist. Sophie?
Thanks, Melissa. So let's take a look at the caseworker hearing checklists. Each of the checklists, back slide there, makes recommendations for caseworker case management to prepare for the hearing, case management during the hearing, case management to prepare for the next hearing, and provides case management tips for workers in cases involving domestic violence. So with respect to that latter bullet point, the checklists include tips for ensuring that each stage of the process takes domestic violence into account by promoting safe participation by the parent survivor and ensuring that case decisions, the judge's findings, outcomes are developed after considering the context of domestic violence. There are a number of hearing checklists within the companion guide that cover key hearings in the abuse neglect process. There's a checklist for the preliminary protective hearing. In many jurisdictions, this is called the shelter care hearing or emergency removal hearing. The adjudication hearing, the disposition hearing, the review hearing, and the annual permanency review hearing. So I'm going to take you on a tour of the preliminary protective hearing checklist as an example of what you can expect to see when you dive into the guide. So you can see from this slide that the judicial role and activities in a hearing are listed to the left, and caseworker role and activities are listed to the right. The slide really is showing you the Cliff Notes version. More detail and narrative are provided in the guide under each of the points that you're seeing on the slide, and I'll give you some flavor of that narrative as I discuss each of these. You'll also be able to see the overlay of the key principles that Melissa outlined for us in each of these points. Each of the checklists also includes a definition or the goals and purposes of each hearing type. So, taking a look at the preliminary protective hearing, the purpose of this hearing is to determine whether probable cause exists that abuse or neglect has occurred, and in cases in which the child is removed from the home, whether the removal was necessary and appropriate. So looking on the judge's side, the activities before the hearing. Well, the Enhanced Resource Guidelines recommend that the judge begin with a bias check to do a self-reflection process to address the possible influence of implicit bias when they preside over hearings. In the Enhanced Resource Guidelines, there's a list of self-reflection questions, a roadmap to engage in a process to help address implicit bias. Those questions include, this is just a few samples, having the judge ask, what assumptions have I made about the cultural identity, genders, and backgrounds of this family? What is my understanding of this family's unique culture and circumstances? How is my decision specific to this child and family? How is the court or child welfare agency's past contact and involvement with this family influenced or might influence my decision making? On the caseworker's side, we recommend doing the same thing, engaging before the hearing in a self-reflection process to address implicit bias. So checking your bias at the door. We also recommend for both judges and caseworkers enhanced training on bias and individual structural and institutional racism. Also for caseworkers, We recommend considering practices around developing and filing the petition. So this refers to avoiding conclusory language in petitions, using facts, not unsupported conclusions. For example, the father has a substance abuse problem. That's a conclusion. Father's substance abuse problem impacts his ability to parent by, and then listing specifics is a fact, not a conclusion. So workers should avoid making allegations against a parent experiencing DV, for example, solely on the basis that children observed the violence. Avoid using failure to protect language directed at the survivor parent. A parent experiencing domestic violence does not have control over where and when the violence might occur. An allegation that the survivor parent needs the services of the court to help protect your children is more appropriate. Judges also have a role in this initial hearing in identifying parents and guardians who should be present or involved and ensuring proper notice to parties. So caseworkers have a role in helping getting everyone there. Have the identity of all parents and or guardians been determined? If not, what diligent search efforts have been made? Has the paternity of all children been legally established, and if so, how? Specifically, what have you done to identify all parents and guardians? Workers need to ensure all legal and custodial parents are served summons to appear and have the opportunity to participate in the hearing. Also before the hearing, judges must review relevant documents and determine whether all parties receive notice and service and determine whether the child is an Indian child, and if so, ensure tribal notification. So judges here are looking for any evidence that the child may be an Indian child to determine whether requirements of the Indian Child Welfare Act apply at this first hearing. So caseworkers have a responsibility to get ICWA right. Have they made an ICWA inquiry, and who have they asked? Is there a tribe entitled to notice? Caseworkers should ask all legal parents, age-appropriate children, and any other known relatives whether the parents or child have Native American or Alaska Native heritage, and ensure tribal notice and secure the attendance of a qualified expert witness if the Indian Child Welfare Act applies. Before the hearing, too, the caseworker should have a responsibility to be a partner with parents and children from the start. So prior to the hearing, really in a meaningful way explain the goals and purpose of the hearing and the importance of attendance. The worker's genuine interaction and engagement as a partner with children and parents at this early stage can set a positive and cooperative tone throughout the case. Domestic violence considerations here from the judge's perspective include requesting that intimate partner violence assessments be provided to the court so a safe hearing environment can be established moving forward. So for the caseworkers, you can see on the card there's some suggested methods and tools developed by the QIC on domestic violence and child welfare that we're encouraging the use of. We also encourage that the workers use trauma-informed engagement strategies with parents and children. This slide here shows you an example of how when a resource is mentioned, there's a link to the reader to obtain those resources. And that's done whenever a resource is identified. At the preliminary protective hearing, probable cause and reasonable or active efforts to prevent placement must be determined. So for the judge, this involves determining jurisdiction, ensuring that the court has jurisdiction by examining whether allegations are filed as to each legal parent, even if one parent is a non-custodial parent. If allegations are not filed as to a legal parent, the child should be placed with that parent. Implications here for the worker is a consideration that non-custodial parents have rights. In most states, the agency must file allegations as to each legal parent for the court to have jurisdiction. A non-custodial parent may need the services of the court to establish a relationship with a child or to secure that legal custody. If there are no allegations as to a non-custodial parent, the child should be placed with that parent. The judge must determine if there was an emergency, determine whether foster care is being utilized only as a last resort, and whether reasonable or active efforts in the case of an Indian child to prevent removal have been made. The judge should ask what prevents the child from returning home today. So implications for workers here is that foster care should only be used as a last resort, and they should be prepared to testify to the very specific efforts that have been made to prevent removal. Workers should document and be prepared to testify to the reasonable or active efforts the agency made to prevent placement. This should be a meaningful presentation of efforts and not just a check the boxes discussion. If the removal was done due to an emergency, the workers should be prepared to fully explain to the court the nature of the emergency and why no efforts could be made to prevent the removal. Considerations in domestic violence cases here are, how did the agency seek to address the domestic violence in the family prior to seeking removal? Or alternatively, why was the immediate removal warranted? Did the adult survivor parent have strategies, protective factors to keep the child safe? And if so, why were those strategies not effective? The judge must also consider if this case involves other matters before different courts which need to be consolidated under one judge. For caseworkers, this means knowing the whole story, informing the court whether there are any other cases involving family members filed in any other court, making sure that the agency's recommendations are not in fact in conflict with other court orders, including protection orders. Still at the hearing, the judge needs to inquire about the need for placement. The judge will be inquiring not only about the reason the child was removed, but also why the child cannot return home today. The reason the child entered care is not a reason to keep the child in care. The judge must weigh the current safety threat at every hearing, determine whether the child needs to remain in placement as a result. So for caseworkers, remember that children should be returned to their parents when their parents can provide the minimally sufficient standard of care. This doesn't mean that the parents need to complete all services. It does mean that children should be returned home when the safety threat is eliminated. So always be able to articulate the safety threat today. If the court orders that the child should remain in care, a number of issues will be explored. The court will be evaluating whether the child's current placement is the most appropriate and least restrictive to meet the family's, the child's needs. The court will inquire about the diligent search for relatives as possible placements at every hearing. For caseworkers, this means getting the placement right from the start. When a child has been removed, make every effort to place the child in the right placement from the start. Relatives should be explored as fully as the time before the first hearing permits. Be prepared to explain to court the diligent efforts made to locate relatives and specifically why the current placement was chosen for the child. The judge will be making a decision, too, about whether services can be provided to allow the child to return home now or in the future. So for caseworkers, there should be a consideration of whether there are services that will mitigate the safety threat and allow the child to safely return. And those services should be rationally or directly related to the reason the child was removed from home and later directly related to the jurisdictional findings of the court. Once probable cause is established, workers need to switch their thinking from why they removed to how they get the child home. The court will determine the frequency of family time or visitation that should be provided. So workers need to be prepared to explain to the court the frequency and level of supervision the agency is recommending. Levels of supervision should be determined based on whether the child can be safe during the visit. The reason for removal is not an automatic reason to recommend supervised visits. The analysis, instead, must be about safety during the visit. So workers should be prepared to explain the potential safety risk during a visit, specifically if the agency is recommending supervised visits. At the end of the hearing, the judge will set the next hearing date while all the parties are present and distribute orders. To prepare for the next hearing, caseworkers must review the court order with the family and update the case plan if necessary to ensure compliance with the court order. What I presented here for the preliminary protective hearing checklist really were the cliff notes with some snapshots of added guidance or detail provided. I hope you can see that they serve as roadmaps to prepare for and participate in thorough hearings. Many of the considerations in the checklist are aimed at helping judges in obtaining or learning more information about the child and family to better inform their decision making. So we hope that using the checklist in conjunction with the detail provided in the companion guide for workers and the original enhanced resource guidelines will help workers provide the court with that comprehensive information. You could argue that some of the information should be presented to the court without the judge needing to ask for it, via reports, high-quality reports to the court, but the court should always be including a thorough discussion of all relevant issues in open court and avoiding total reliance on written reports. So workers should be prepared for that, and hopefully checklists that identify the key expectations for information that judges have for hearings will help, and then how caseworkers can address those expectations will help them be better prepared to be effective in the hearing process. With that, I'll turn it over to Melissa.
Thank you, Sophie. At this time, we're going to go ahead and open it up for questions. So you are welcome to type your questions in the chat, or if you would like to verbally ask, you could certainly raise your hand with the icon on the top of the screen. The little guy with the raised hand, just click on that, and we'll unmute your phone line. So we'll give you a moment to do that. And it looks like we have a question from Ms. Santangelo. What's your question?
Yes, hi, how are you? I'm the CIP coordinator in Delaware, and first of all, this is extremely helpful, and I want to say that I don't think a lot of our caseworkers kind of provide the detail that you're suggesting for that. I guess I'm just wondering, as far as, is there like an enhanced training? Like, is this like just kind of like a brief overview of it? Do you do something that's more in depth that we could provide for our caseworkers to kind of get them to that point? I definitely think it's a mindset where I don't think they view their mind as them being there to reunify so much, or that they're really on the quote-unquote side of the family and the youth. So I don't really see them kind of making a lot of efforts to keep them together or reunify. I guess I know that was a lot, but.
Yeah, no problem, Joanne. So this webinar purpose today was just mostly the unveiling so that we could inform folks about the actual resource itself, which is available on the NCJ-FCJ website. So if you'd like to view the larger document to see all the hearing checklists, it's on there. We certainly would be, definitely open to providing some more in-depth training, and I will connect with you after. I have your email address, I believe, so I can send an email to you, and we could certainly talk about how we can assist with that.
That would be great. Thank you.
Thank you. Are there any other questions from anyone?
This is Sophie. I would just add to what you said, Melissa, in response to Joanne, that some of the most effective trainings I've seen about preparing for, participating in, and following up after abuse neglect hearings have been interdisciplinary or multidisciplinary, where caseworkers are teamed with judges and attorneys to really discuss expectations for practice in hearings. So I think moving forward, you might want to consider, yes, having enhanced training for the caseworkers, but overlaying that with an opportunity for them to engage in training with judges and attorney stakeholders as well on items such as, the practices that these checklists outline.
Thank you. Yes, we do do a lot of interdisciplinary and stakeholder statewide trainings, and actually we're going to take part in the next Judicial Academy. We have some of our judges participating in that around the Enhanced Resource Guidelines. So I was even thinking, now that you say this, maybe once that training is done, then kind of bringing everyone back together and then making sure the judges that attended the Enhanced Resource Guideline were also present, because then I think this is something helpful for our judges as well, because I definitely don't see some of them asking those deeper questions that they probably should. So I think to your point, yes, including the judges would be helpful, and then maybe as a follow-up to the Judicial Academy might be good timing for everybody.
Yes, that sounds like a really good timing.
Absolutely. And Joanne, we can discuss that for sure. And Mark Funkhauser is on the line, and he's actually been working with Chief Judge Newell around the implementation sites project that the council has been supporting around the implementation of the Enhanced Resource Guidelines. So I think it's just a really good time to just connect all the dots. So this is amazing. Thank you so much. Do we have any other questions at all? Well, we'd certainly like to thank each of you for your participation today. And we see that this is going to be an important tool and something I think that will be helpful to inform the field around enhancing practice related to how caseworkers can complement sort of the Enhanced Resource Guidelines and work closely with court partners, specifically focused on permanency and well-being outcomes for not only children and families, but also survivors of domestic violence that are involved in child abuse and neglect systems. And we certainly, again, like I said, thank you very much for the opportunity to talk with you today. To download the entire companion guide, you can visit the NCJ FCJ website and download that for free. And if you have any other questions about anything, my email address here is on the slide, and you certainly can reach out. And so thank you so much.
Thank you, everybody.